Alex here with a video on Mike Lindell running out of money, also known as the My Pillow guy. I'm going to give you guys some context by running a short clip. There's a lot of stuff out there, including the deposition videos, which if you guys are interested, please watch. They're pretty good. But I'm going to skip those portions because they're political.
But earlier this month, the Minnesota businessman claimed he's broke and all of his lawyers quit as he faces a number of libel lawsuits. Tonight, Lou catches us up with the latest and what Mike Lindell is telling the people who support him tonight.
So, as I mentioned, if you guys get a chance, watch some of the depositions. And this isn't even, I should probably talk about this. As outrageous as the depositions seem, I've seen way worse. There's other ones floating around on YouTube that are way worse than the Mike Lindell depositions. And we had an incident in Nevada where a gun was involved at a deposition, and it wasn't even the litigant, it was the attorneys. In fact, the attorney got disciplined by the state bar. So this isn't even the worst situation. And the reason I decided to talk about this was because on top of getting people requesting for me to cover this video, I got questions specific to my case about the evidentiary hearing where I ended up getting physical custody of my son and why I hired an attorney for that specific hearing. Now, to me, it was obvious, but of course, I've been representing myself, or was representing myself, for 8 years. So this problem that Mr. Lindell is going through ties into the questions that some of the people have that are just related to ignorance, not stupidity, just ignorance, just not knowing how the court system works. And I think that this starts out with the fact that the litigants who make this mistake are both emotional and ignorant about the legal system. It takes these two things combined to cause this pattern to occur, and I've seen it occur in all types of cases. Criminal cases, family court cases, money cases, it doesn't matter. If the litigant is emotional and the litigant doesn't know how the court system works, they make this mistake. And I think it's because the instinct of these particular people, which includes family court litigants, is to resist 100% maximum at all stages possible. That's just the natural instinct people have when they're in a situation that pisses them off and they don't want to, I guess you could say, help their opponent defeat them. And so they think to themselves, I'm going to fight kicking and screaming at every possible hearing, every possible motion, all the way till the end. That's what people, I suppose people think all the way to the end. I'm not sure some people are even thinking that far ahead. Some people think that it's just an injustice that they're even in the system and that it's obviously going to get dismissed or thrown out at the next hearing. And then they have another hearing and another hearing and another hearing. And then they get confused and they're like, why am I being tortured? Why? The problem is the ignorance comes into play. Dismissing a lawsuit in this country, for the most part, at the early stage or the summary judgment stage, is designed to be difficult. It's on purpose. They made it that way. They made it that way because when you get to the question of a jury, or even if it's just a bench trial where the facts are determined, that just tends to be what needs to occur in most cases. In most cases, facts are at issue. In most cases, they have to be resolved. And unfortunately, people don't know that the court can't deal with those problems in the beginning phase or in the middle phase. I talk about this in the video early case termination and mid case termination. So the system is designed to not allow a case to be thrown out prematurely. It happens, especially when somebody doesn't know what they're doing and they fail to state a claim, especially when somebody doesn't know how to do, handle their discovery phase, typically a pro se litigant, and they mess up in the evidentiary, the evidence gathering phase, and they aren't able to show that they have something to present to the jury. But this is like not the most common situation. The most common situation, at least for this channel, is family court. And those cases are just not going to get thrown out in the beginning or middle. They just aren't. They're going to end up somebody's going to end up giving up, which happens a lot, or they're going to end up going to the trial. So with this particular situation, Mr. Lindell, which is a money case, I can think of multiple examples with our Nevada judges where I saw the exact same thing happen. You would think it would be the least emotional situation, but no, people don't know how the court system works. They get upset and they start going into kicking and screaming mode. And so what ends up happening is they run out of money. Whether it's a criminal case, they run out of money and end up with the public defender. Whether it's a situation like Mr. Lindell, they run out of money and lose their attorney. Family court's a little weird. Yes, I do see it happen a ton, that these cases, a ton. People run out of money and they end up representing themselves. But I also see it happening where people just start out representing themselves, and in some cases, those particular people are abusive and they use the right to represent themselves to drag the proceedings out to their opponent's detriment. But more often than not, they drag the proceedings out to their own detriment, not to their opponents. So I think that, and I've talked about this before, and a lot of people don't like to hear this. I know that a lot of people don't like to hear this. But if you know a lot about the court system and how it works, in many of these cases where a person does have a valid defense and they do have a good chance of winning their case, and they just don't have $25 million in the bank, the best thing for them to do is to get through the early and mid case as efficiently as they possibly can and mount a defense at trial. And especially for criminal cases where all of their powerful rights kick in, like beyond a reasonable doubt, right to a jury, all that stuff kicks in at the trial. And I can think of like 5 different examples of criminal cases covered with our Nevada judges where they just fought like crazy to get the charges dismissed, which people who know about criminal court know that that's a very, very rare thing that happens in criminal court. It's so rare, and they either don't realize that or don't care, and they file a ton of motions to dismiss and all habeas corpus, and they chew through all this money, and then the point where they're most likely to win, where they're in the most advantageous position possible, oh, they're out of money and they have no attorney. I think that a lot of these situations, the outcomes would be different. And I'm only talking about the people who actually have a meritorious defense. I'm not talking about the people who have a losing case right from the beginning. I mean, I understand their situation. They just don't have a leg to stand on. And in their mind, if they just have a crappy case, then all they're going to do is drag it out, see what happens. And then if they lose after wasting everyone's time and money, oh, well, who cares, because they didn't have a good case anyway. I'm talking about the people who actually do have a good case, who do have an ability to win at trial, and they sadly don't realize the importance of preserving your money for that point, and fight, run out of money, end up representing themselves, and then losing at trial. Seen that so many times. I hope that this video makes a lot of sense to people who are watching. It's just a problem of not having enough money, which most people can't solve, and not knowing how the court system works, which I think most people can solve. You know, by watching this channel, I think a lot of people have figured out the importance of understanding how the court system works so that they apply resistance to the points that are appropriate and most optimally to succeed, and that they don't apply resistance to the pointless areas of the lawsuit. So I don't know if I have anything else that I can think of on this topic. If you guys have any questions, of course, feel free to post them down in the comments below, and I will see you guys next time.